As we wait for the final few people to come in, just a couple housekeeping details. We will be sharing the slide deck and you can have access to the video recording. So that's always a popular question. So yes, they will be shared. Also, if you have other questions during the course of the webinar, please use the Q&A function in Zoom. Put your questions in there. We'll try to respond to as many questions as we can. At the end, I will always leave time at the end of the hour or before the end of the hour to address the questions that come through. Please don't use the chat. We do use the chat ourselves to give you information about links, but that's not the most efficient way to capture the questions. So please use the Q&A function for the questions.
All right, Erin, it looks like a good majority of our registrants have joined us. Do you want to go ahead and get started?
Sounds good. Thank you so much, Amber. And good morning to everyone. My name is Erin Choquette, and I will be your presenter this morning. I am joined by Amber Forrest, who, and two of us are from the Connecticut Paid Leave Authority. So I'm the general counsel. I'm an employment lawyer. I've been working for the state for over 15 years, and that's all you need to know about me. And let's get into the contents, which is really what you want to know. This morning, we're going to give you a little bit of information about the paid leave program, but then we're really going to focus on making sure that you can understand the two sort of laws that we really are focusing on today, FMLA and Connecticut Paid Leave. And then we're going to talk about how those laws are going to be implemented. We will be sharing with you some resources that you can take away and some links. And as I said, we will have time for questions toward the end. Please use the Q&A function, not the chat, for your questions. With the Leave Authority, we are a new entity. We are a quasi-public agency that was created by statute with the mission of creating a program that allows workers who can't work because they are sick or need to care for a family member to have access to income replacement benefits while they're out of work. So that's the goal. We also think it's incredibly important for sort of the seamless operation to make sure that everybody understands their roles and responsibilities. And so we think it's very important to reach out to employers, administrators, healthcare providers to make sure that they have the tools they need to fulfill their roles in this process. At the authority, we're small but mighty, and we have a lot to do. We do have a statutory responsibility to engage in outreach and education, which is one of the reasons we offer so many webinars and really try very hard to make sure people understand the program. So you'll see us out in the community as much as possible. We're going to be hitting the radio waves and billboards, so we're trying to make sure people know about us. As I said, we're brand new, so we've been setting up the agency while we're setting up the program. As a quasi-public agency, we issue policies that are adopted by a board of directors after a public notice and comment period. We don't have regulations, but all of our policies are adopted after a public comment. We have to fund the program. The program is funded by employee contributions, so we receive those contributions. Right now, the statute says that the contribution rate is capped at 0.5%. In the future, if the trust fund reserves get nice and healthy, we have the authority to reduce that contribution rate. There's something that we have, we call it private plan process. It's an alternative way for employers to fulfill their obligations under the paid leave program. So you're not opting out of paid leave, you're complying in an alternative way by offering your employees a private plan that does the same things or better, more generous than the paid leave authority. If employers are interested in that, they have to apply to the authority and we have to approve it and then we'll audit it. We are in the process of adopting our final regulation or policies related to private plans, and we will be issuing new webinars in the coming month to talk about sort of the new private plan process. So we won't really talk about that pretty much at all today. What we will talk about is the fact that we will be administering claims for paid leave benefits, and we'll talk about when that goes into effect and how we'll be doing that. Just a quick timeline of the things we've been working on for the past 12 months and going into the next year. Employers were asked to register with the Connecticut Paid Leave Authority before January 1st. We wanted employers to register so that when they had to remit their contributions in January, they knew where they were going and what they were doing. And employer registration is still open. That will always be open, as new business is open all the time. As I mentioned, contribution obligations started in January. So employers were supposed to begin deducting those contributions as of January 1st, and they get remitted on a quarterly basis, although we do allow a 1-month grace period at the end of each quarter. So, for example, third quarter contributions ended, or the third quarter ended on September 30th, but we give everyone until the end of October to remit those contributions. So those contributions should be coming in today. Starting in December, we will start accepting applications for income replacement benefits. We won't actually issue any payments until January because the program starts in January, but we wanted to open applications early so we can smooth out that initial kind of rush. So if anyone is interested and is expecting benefits, they can start applying in December. As a lawyer, I always like to make sure that we're using our terms in a defined way. And one of the first terms that we really need to define is who are workers, who's covered by this program. The short answer is almost every worker in Connecticut. Employers who have one or more people working for them in Connecticut are covered under our program. This includes nonprofits. This includes private sector employers with unionized workforces. We know that we got lots of questions about those two groups. Yep, you are covered. Even if you are not subject to unemployment insurance obligations, you are subject to the Connecticut Paid Leave Authority and the Connecticut Paid Leave Act. Sole proprietors and self-employed individuals are not required to participate for themselves, but they can choose to opt in if they want to, and they just have to enroll with us. But then they have to stay with us for at least 3 years. The statute does explicitly exclude certain categories of employers from participation. That list includes the federal government because they're a sovereign entity and we can't tell them what to do. The state of Connecticut is excluded except as to our covered public employees. Municipalities and local or regional boards of education are also excluded unless they have covered public employees. More about that in a second. Non-public elementary or secondary schools are also excluded. This is generally the same list of entities, with the exception of the state, that are excluded from Connecticut Fmla. So the two laws are separate but related, and this is one of the areas where you see overlap. Now, there are also other laws that we have to pay attention to. So they may not be listed in our statute, but there are other laws that exempt particular employees from participation in our program. For example, railroad workers are covered by a federal law that provides railroad workers with their own disability program, so they're out of our program. Individuals who are employed by the governments of other states or sovereign nations like Mashantucket are not under our control. Just like the federal government, we can't tell other sovereign entities what to do. So those employees are out. And then there are two tweaky little exceptions that you probably are already aware of if they work for you, because they don't pay any income taxes in Connecticut. Specifically, employees engaged in interstate commerce, and here I'm really talking about actually engaged in the commerce itself, so interstate truckers primarily, who work in Connecticut but live in another state, don't pay income tax to Connecticut, and they would also not be subject to the Connecticut Paid Leave contribution. Similarly, spouses of active duty military members who have opted to continue paying taxes in their home state instead of where they are currently deployed have there's a federal law that gives them that option. If they've exercised that option, they wouldn't be paying taxes in Connecticut, and so they also wouldn't be paying into the Connecticut Paid Leave program. Again, if you have these employees, you know it because you've already excluded them from your other taxes. So I promised to define covered public employees for you. These are people who are working for a public entity and participate in the paid leave program. We contribute to the program and could apply for benefits. So non-unionized employees of the state of Connecticut do participate. Managers, appointed officials, legislators, judges, where we all participate. Unionized employees of the state of Connecticut will only become covered if they collectively bargain to become included in the program. For employees of municipalities and local and regional boards of education, they are excluded unless the unionized employees of that town or board collectively bargain to be included. And if that happens, the non-union folks become included as well. So let's talk a little bit about those contributions. As I said, one of the responsibilities of the paid leave program, the authority is to manage the contributions. Employees fund the program by their 1/2% contribution, and the wages are calculated the same way you currently calculate the employee's FICA obligations. And the reason we use that FICA number is because the statute says contributions are capped at the Social Security contribution limit, which is currently $142,800. So in order to make sure that we comply with that piece, we have to use the same calculations, and that's the FICA number. Even though the employers do not contribute any money into the program, they are responsible for making sure that the employees' contributions come in because they're responsible for payroll. So the employer has to deduct the contributions from the employee's wages and remit those contributions to the authority on a quarterly basis with some very basic wage information. If the employer fails to fulfill this responsibility, it could find itself on the hook for paying the employee's share, because the employees have no way of remitting the contributions without the employer fulfilling its contribution responsibility. But let's assume you're all doing what you're supposed to do, and you're taking those deductions, you remit them to us on a quarterly basis. The money goes straight into a paid leave trust. It is not considered a state asset, and it cannot be used for any purpose other than administering the program and funding the benefits. It is overseen by the Office of the State Treasurer. Again, it's not considered state money and can't be used for any other purpose. All right, that's sort of the quickest overview I can give of the Connecticut Paid Leave Program. Let's talk about the laws that really inform our actions. We've got FMLA and CTPL. What is FMLA? Well, the letters stand for Family and Medical Leave Act. There are actually a few different FMLAs, but we're only going to talk about two. The federal FMLA, which applies to employers with 50 or more employees, as well as any public or state or municipal government. And there's also a Connecticut FMLA. Both of these laws allow eligible employees to take job-protected time away from work for specific reasons. And both laws state that the leave is unpaid, but the employer may adopt policies to provide income replacement to their employees during leave. And that income replacement could take the effect of just keeping them on your payroll, just paying them their regular salary, or what we see more often is requiring or permitting employees to use their earned accruals while they're out on leave. There was talk about making changes to federal FMLA, but that does not seem to be happening. But Connecticut FMLA has already been changed, and those changes will take effect in January of 2022. So let's talk about that. The current FMLA in Connecticut applies only to employers with 75 or more employees. But as of January 1st, it will start applying to employers with 1 or more employees. So if you're a smaller business, you may not have dealt with Connecticut FMLA before, but you will have to now. The eligibility requirement for getting leave is also changing. Up until now, it's been that you have to work for the employer for at least 12 months and have worked at least 1,000 hours in the 12 months immediately preceding the first day of leave. But starting in January, the hours worked requirement goes away, and an employee can be eligible for job-protected leave after 3 months. The amount of leave is also changing. It's going from 16 weeks in a 24-month period to 12 weeks in a 12-month period. There's a right to an additional leave if you're taking military caregiver leave. That stays, but under the new entitlements, there's an option for a pregnant woman to receive an additional 2 weeks of leave if they experience a serious health condition during their pregnancy. Finally, the other big change that we want to focus on is relating to when employers can require employees to use their accrued time. As I mentioned, the employer can require or permit an employee to use their accruals while they're out on Connecticut Fmla. But starting in January, the employer cannot insist that the employee exhaust all their accruals. You'd have to let them hold on to at least 2 weeks of PTO so that they can use it for other purposes. FMLA, what is CTPL? Well, we use CTPL to refer to the Connecticut paid leave. We kind of use it in 3 ways: to talk about the Connecticut Paid Leave Act, to talk about our program, or to talk about the authority. But today, when I talk about CTPL, I'm going to be talking about the Connecticut Paid Leave Act. This is a Connecticut law, and it creates a source of income replacement benefits. It does not provide job protected leave. You might also hear us or other people refer to it as PFML, or Paid Family Medical Leave. Connecticut Paid Leave and Connecticut FMLA are separate laws. They are related, but they are separate. One of the areas where they're related is the reasons. So the reasons to take job protected leave under Connecticut FMLA and the reasons that a person could be eligible to receive income replacement are the same. And they are to take time off to receive treatment or recover from your own serious health condition, which we call medical leave. And serious health condition includes pregnancy, as well as being an organ or bone marrow donor, as well as other definitions that you can find on our website, or I can answer if we have questions later on. There's also caregiver leave, which is when you take leave, receive benefits to care for a family member who has a serious health condition. Then there's the happy one, that's the bonding leave. So you're taking time to bond with your newborn or a newly placed adopted or foster child. As I mentioned, there's something called military caregiver leave, which is actually a longer entitlement. That's leave to care for a family member who's been injured on active duty in the military. That's a one-time per service member per injury entitlement, but you can get up to 26 weeks of leave for that reason. There's also something called qualifying exigency leave, which is leave to address specific issues that are listed in the statute that are associated with a parent or spouse or child's deployment to active duty in the military. Finally, there's something called family violence leave. The Connecticut FMLA itself doesn't talk about family violence leave, but the very next statute in the books, 3151 SS, is a specific statute in Connecticut that says an employee has the right to take up to 12 calendar days for unpaid leave to address specific issues relating to the fact that they are directly experiencing family violence. They can go to court, they can relocate, they can receive treatment or counseling, and an employee could receive income replacement benefits from CTPL for those 12 days. I want to take a minute to focus on caregiver leave because caregiver leave under Connecticut FMLA is changing as of January 1st. Right now, and under federal FMLA, if you're used to that, caregiver leave is only available for an employee who wants to take time to care for their parent or their spouse or their child who is under the age of 18 or is 18 and older and has a disability as defined by the ADA, which prevents them from engaging in 3 or more activities of daily living. So it's a pretty small circle of people that you can take caregiver leave for under federal FMLA and under existing Connecticut FMLA. But starting in January, you'll be able to take caregiver leave under Connecticut FMLA for more people, and you'll be able to receive income replacement benefits if you're out of work to be a caregiver for your parent or spouse, or son or daughter of any age, or your sibling, grandparent, or grandchild. And I should note that all of these include in-laws, as well as the direct relationship. And you can also take leave to care for an individual related to the employee by blood or affinity whose close association the employee shows to be the equivalent of one of these family relationships. So what does that mean? Well, this affinity relationship is somewhat new to Connecticut, but it has existed under federal government for years, and other states and municipalities have used it. So we've adopted their standards. Basically, it's a recognition that families come in all shapes and sizes. It may not look like the Keatons from Family Ties, right? It might look more like my 2 dads. So what we are saying is that the employee has to demonstrate to the employer or to the authority that they have a significant personal bond that is like one of those relationships I listed. So this is very fact specific. The Connecticut DOL has indicated that the demonstration should take the form of a writing. It can't be an affidavit, and you can't ask them for 10 years worth of photo albums, but you can have the employee write and explain the relationship and how it is the equivalent of one of those parent, spouse, or child, family, sibling, grandparent. So perhaps it's the aunt or uncle who is really stood in the role of a parent or a grandparent to you. Connecticut doesn't recognize common law marriage, but under this new definition, your unmarried significant other with whom you maintain a spouse-like relationship would be considered to be the equivalent of a spouse, even though they don't have a marriage certificate. Summary, the next couple of slides are just really for the ease and takeaway. Just to be eligible for FMLA under the federal law, you have to be employed by the employer for at least 12 months and work at least 1,250 hours in the 12 months immediately preceding leave. This applies to you if you have 50 or more employees. Under Connecticut FMLA, starting in January, as we've talked about, it's the one or more employee, and you have to be working for that employer for at least 3 months. To be eligible for Connecticut paid leave income replacement benefits, we don't actually look at how long you've worked for the employer, because our entitlement is meant to be portable. So we look at how much the employee has earned from one or more employers in the first 4 of the 5 most recently completed quarters. If the employee has earned at least $2,325 in that highest earning quarter, and they are currently employed and working in Connecticut, or if they're not, had they been employed working in Connecticut at some point in the 12 weeks before they apply to us, then they can receive benefits. In addition, a sole proprietor or self-employed individual residing in Connecticut who is enrolled in the Connecticut Paid Leave Program can get benefits based on their self-employment earnings. Again, just sort of a quick takeaway, the entitlement is 12 weeks of leave in a 12-month period under both federal FMLA and Connecticut FMLA, except both of those laws allow for 26 weeks for caregiver leave. As we've talked about, the Family Violence Leave Act also provides for 12 days for the family violence leave reasons, and there may be 2 additional weeks for an incapacitation during pregnancy. For income replacement benefits, you could receive up to 12 weeks of income replacement benefits in a 12-month period for all of the leave reasons, including military caregiver, with the exception that we only provide 12 days of income replacement benefits to cover those 12 days of family violence leave. And we do allow for 2 additional weeks of income replacement if an employee is out for additional leave during their pregnancy. If you remember the number 12, you can't go too far wrong. Even though we're focusing today on Connecticut FMLA and Connecticut paid leave, I want you to remember that there are other laws that provide job protection and income replacement, including Workers' Comp, Americans with Disabilities Act, the Pregnancy Disability Act, and the Connecticut Fair Employment Practices Act. So you have to sort of pay attention to those laws, keep them in your mind, and make sure you're thinking about, is my employee eligible for any benefits or job protection under these laws? I can tell you that, as we indicate here, most of the laws really only talk about job protection. Workers' Comp is really the only other one that provides income replacement, and an employee who's receiving Workers' Comp benefits is barred from getting any CTPL benefits. So let's talk about the implementation of these different statutes. Well, as we've talked about, Connecticut paid leave is in 2 parts. There's the contributions and the claims. And so this slide really just describes who does what with regard to the contributions. The employees contribute the money. The employers are responsible for getting that money over to us. We receive the money. We process any over or underpayments, and we will start imposing penalties for noncompliance. We made a policy decision not to have any penalties this year since it's the first year. We really want to focus on education and compliance. But starting next year, employers that do not fulfill their obligation could see penalties in addition to being responsible to cover the employees' contributions that they did not take. So there could be additional penalties beyond that fact. Connecticut DOL doesn't have any direct role with the contributions, but this year in connection with their general wage and hour authority, they did allow employers to take catch-up contributions if they were unable to start doing those deductions in January. That kind of global catch-up period ended in September. So if you are not quite caught up and you didn't take advantage of that catch-up period that lasted from January to September, you could reach out to DOL and see if they'll give you an exception to continue taking additional contributions to get caught up. But more likely than not, you will have to cover those employee contributions because it's not the employee's fault that they couldn't make the contributions. It's the employer's lack of fulfilling their responsibility. On the claim side, there's really most of the responsibility lies with the worker and the paid leave authority. So the worker is responsible for submitting the application to us. The employer doesn't do that. They may have to provide documentation. If they do it online, they'll create an account with our authority, and then we'll transfer them over to our third-party administrator, AFLAC. We've contracted with AFLAC to handle the claims processing for us. By statute, workers are required to notify their employer if they're making a claim with us. The employer is required to complete and submit an employment verification form, and we may need the employer to validate absences or other sources of money as needed. But that's about it in terms of the claims. You really don't have much of a responsibility with regard to your employee's application for benefits. You do need to notify your worker if you have any paid time off policies or short-term disability insurance policies so that they can report accurately to us. And as with pretty much all of these laws, you can't discriminate or retaliate against an employee who's exercised their right under the laws. We'll talk in a minute about all the things that the authority will do with AFLAC, but basically we're processing the claims. And the Connecticut Department of Labor has the authority to hear appeals if we deny a claim or impose penalties. In this case, we're talking about penalties relating to fraud in the pursuit of a claim. So what does this look like? Well, the worker submits the claim. They can either call AFLAC directly or go to our website and click on the Submit a Claim button. And they'll submit supporting documentation explaining how long they're going to be out and what they need for income replacement. We only provide income replacement if they're out of work. AFLAC will determine the eligibility, making sure that they've earned the right amount of money and they work for a covered employer. And they will either, if they're eligible, they will move forward to reviewing the documentation and approving or denying the claim. They'll calculate the benefits using the statutory calculation method and issue those benefit payments. Payments will be issued either through electronic transfer or a stored value card, basically a debit card. We are planning to issue benefits every Tuesday. We're saying they're issued 2 weeks in arrears. Technically, it's like 10 days. So for example, the first week of January, from January 2nd to January 8th, if someone is out and isn't approved for benefits, they would receive the benefits on the 18th. This gives us time to make sure that the calculation is correct and that we're taking into consideration any employer-provided benefits before we issue the payment. The worker is responsible for notifying us of any changes in their circumstances, including whether they go back to work earlier or need to stay out later, or if they receive other income that we need to take into consideration. As I said, the calculation for the benefits is set forth in statute, and it is based on how much the worker earns in their base period. Their base period is the 2 highest earning quarters when we look at the first 4 of the 5 most recently completed quarters. And if their base weekly earnings is less than or equal to the minimum wage times 40, their benefit will be 95% of those base weekly earnings. If their base weekly earnings exceed the minimum wage times 40, we'll get that 95% up to the Connecticut minimum wage times 40, plus 60% of the difference. However, in all circumstances, the benefits are capped at 60 times the Connecticut minimum wage. So just like the contributions are capped, so too are the benefits. So what does this look like? Well, if you want to see the math, that's what this slide is for. 40 times the Connecticut minimum wage is $520, so 95% of that would be $494. Worker B, we just show that it's a 2-step process. You've got the 95% of 40 times 13, plus 60% of the difference between what the worker is earning and 40 times the Connecticut minimum wage. In this example, that's an additional $12. All right. We get asked, what happens when the employer wants to provide PTO or some other income replacement to the employee? How does this work? Well, our statute says that employees can receive Connecticut paid leave benefits and employer-provided benefits at the same time, as long as the total amount does not exceed 100%. And Connecticut Fmla says the employer can require or permit an employee to use PTO while they're using Connecticut Fmla, as long as you let them hold on to 2 weeks. And for employers, you may want to require your employees to use PTO if you're concerned about them stacking, basically layering one source of job protection on top of another to extend out their protection. If you require them to use their PTO, you can help kind of manage how long they're going to be out. So employers can make that decision. We just need to know what you're going to do. If the worker has no PTO or other source of employer-provided benefits, like a short-term disability policy, then it's pretty straightforward. The worker would receive the full amount of CTPL benefits for the full period of the leave. The leave would start on January 2nd. The benefits would be paid as of January 2nd going forward. On the other hand, say the employer says, I want you to use all your sick time, understanding you have to keep 2 weeks in reserve for PTO, but I want you to use the PTO you have while you're out on Connecticut Fmla. And that PTO is enough to cover the full leave, then that's the employer's right. The employee is paid during the full leave, so they're okay. And they're not even touching their CTPL benefits, so that remains untouched and available to them if they ever need it in the future. If a worker has enough PTO to cover part of their leave, so say they only have a few weeks and they have to have the 2 weeks kept in reserve, so they're only going to use 1 week of employer-provided PTO, and then they're going to start getting CTPL benefits in week 2. Their Connecticut Fmla starts on week 1, CTPL will start on week 2. Some employers have policies or possibly short-term disability insurance plans that say, we'll start from the beginning, but we'll pay less than the full amount. So that's when we have to coordinate to make sure that the Connecticut paid leave benefits plus the employer-provided benefits together do not exceed more than 100% of the employee's regular wages. We are actually in the process of updating our draft employment verification forms so that employers can, in an easy and succinct way, give us the information we need to understand which bucket the employee falls into, and then we can make sure that we're complying with the law and the employer knows what to do. So what do your workers need to know? Well, they need to know if you will require or permit them to use their PTO while they're out on leave and what the rules are. And they also need to know if you offer short-term disability insurance, whether the policy is the payer of last resort, so that they use everything else first, or whether they are the first payer. And you need to know how much they pay and if they'll reduce it based on other benefits. That's going to be something you have to look at your own policy. We can't tell you what that is because it's your policy. So that's Connecticut paid leave. Let's talk about Connecticut Fmla, which is a separate law, separate entitlement. Connecticut Fmla allows for an employee to receive job protected time away from work. And the real relationship here is between the worker and the employer. The worker has to tell the employer that they need leave and give the employer the documentation, and the employer has to manage the leave. The Connecticut Paid Leave Authority has no official responsibilities relating to Connecticut Fmla, but we've learned that it's really hard to talk about Connecticut paid leave without explaining Fmla so that we can explain the differences. The Connecticut Department of Labor is responsible for enforcing the Connecticut Fmla. They are in the process of updating their regulations, and those should hopefully be posted in the next month or so. And they are already providing guidance about the interaction of the new Fmla laws. and they will be responsible for investigating complaints regarding denials of FMLA leave, as well as claims that employees have been discriminated against or retaliated against because they exercise their rights under Connecticut Fmla. So, as I said, this is really a process that goes between the worker and the employer. It starts when the worker notifies the employer they need time away from work. They do not need to use the term FMLA. They just need to give the employer enough information for the employer to reasonably believe that, this sounds like one of those leave reasons in that early slide. They're supposed to give the notice 30 days in advance if the reason for leave is foreseeable, or as soon as practicable if the need for leave is not foreseeable. The employer has 5 business days to determine if the employee is eligible for Connecticut Fmla or federal FMLA or the other protections, and to notify the employee if they're eligible, and provide something called a Notice of Rights and Responsibilities. Connecticut UL is updating this form, so you should have that available to you before January. And that form tells the employee what they have to do and also tells them if they have to provide any additional documentation. This is not leave approval. This is just, yep, you're eligible. And we have to see these documents to determine if you get leave. I should note, all of these things I'm saying right now in terms of the time frames, they're based on the Connecticut and federal FMLA. But if you want your worker to comply with these time frames, particularly the notice, you have to have a policy or a notice to employees telling them that these are the requirements. If you don't tell the employee that they have to give you notice or provide you with documentation, you can't hold it against them if they fail to do so. You've told the worker that they need to provide you with documentation, and it's based on the type of leave they need. You have to give them at least 15 calendar days to provide that documentation. And if they tell you that they're having trouble getting it, you do have an obligation to give them a reasonable amount of additional time, usually another week or another couple weeks. If they don't tell you they need additional time, then that's on them. But if they talk to you, you have to be reasonable. Once you get those documents, you have 5 business days to determine if they're complete and sufficient, and if they are, to either approve or deny the leave based on the documents. When you, let's say it's approved, you have to tell them if they have to use their paid time off, if they have to report in, if they need a fitness for duty, if they're out for their own serious health condition. All of that needs to be included in the approval designation. Again, CTPL is working on updating those designation forms, or you can look at the federal DOL's website. They have forms as well. If we're talking about a foreseeable leave and the employee has given you the advance notice, all of this work is going to be done before the employee even goes out. Or perhaps the employee has a condition where they have one serious health condition, but it causes flare-ups. So they're out on a sporadic basis, or we call it intermittent leave. So several sort of small leaves, a day, a couple hours for the same leave reason. Whenever they're out on an FMLA covered leave, they have to call in and tell you, hey, this is my FMLA reason. They can't just say, I'm not feeling well, or they can't ghost you. You're supposed to call in so you can track their leave usage, because you want to make sure they're not exceeding the 12 weeks. Now, the whole reason for FMLA is job protection. So you have to give the employee their job back. It has to be the job they had before they went out on leave. And if and only if that job has disappeared, not because you've reassigned the work while they're out, but you've really, the job has gone away, you can give them an equivalent job. Just a reminder, you do have to consider the ADA and the Pregnancy Disability Act and Connecticut Fair Employment Practices Act with regard to employees who are out on their own serious health condition. You want to be careful about 100% fit for duty or total recovery policies, because those may violate the ADA. FMLA is not easy. I'm not going to pretend it's like a walk in the park. But if you're organized in detail and you focus on the details, it is something you can manage. First thing, you really need to manage your workers' absences. So you need a good attendance policy and call-in policies so you know when they're out. You make sure that your managers and supervisors let your operations or your HR folks know when the employees are out so HR can do what they need to do. For medical leave and caregiver leave, the key document is that MedCert. you want to get a good med cert. We have a sample med cert that we'll be using that you can use as well. I think DOL is developing a sample med cert. Federal DOL has one as well. Insist on a good med cert. You can't get their entire medical file. You can't get information that's unrelated to the leave, but you are entitled to know that they are going to be out for a covered reason with reasonable estimates about how long they're going to be out. Now, employees who take intermittent leave, usually those absences, at least they may be unforeseen. So you really need to have a good understanding of your estimated time, how frequently they'll be out, and how long each absence might be. And you really want to keep track of those. Also, if you have employees who work overtime or part-time, your work week is based on your average number of hours worked. So part-time workers, their work week is, maybe it's 20 hours. So they get 12 20-hour weeks. Someone who works a lot of overtime, maybe their average hours is 50 hours a week. So they get 12 50-hour weeks. So you need to pay attention to that and calculate that average work week. And then if they're not working, you deduct the time. If they can't work overtime because they're a caregiver, you deduct the regular overtime out of that allotment. Again, pay attention to the other laws. If you're subject to federal FMLA, you have to track federal FMLA separately. Please know, in all circumstances, it's the employer's right and responsibility to designate time off that qualifies under FMLA as FMLA. Even if the worker says, oh, don't do that, I want to save my FMLA for some other reason. No, that is a trap. You could get hit with a denial of FMLA claim, and you can't say, oh, well, they told me not to do it. You're responsible for designating it. And it's better for you to make sure it's designated so you can make sure you're tracking the time. Gives you a lot of information in a very short amount of time. And so you may want to check out our website and look for additional resources. We have employer toolkits, we have a small employer toolkit, we have an HR toolkit, we have posters, we have rec cards, we have fact sheets, we have videos. They're all available on our website. They're all available in English and Spanish. Black and white and color if you want to print them out or email them. So we don't want you to have to go it alone. You can also check out our website for frequently asked questions. We are updating that list all the time. And we have videos both on our website and on our YouTube channel. So Connecticut Paid Leave Authority on YouTube. And if you have additional questions that aren't answered from these resources, you can always submit a question to us through our Contact Us page. You submit the question and you tell us, do you want an email back or a phone call back? And we will go with whichever you ask. We don't have a phone line right now. Frankly, it's not a good use of money. We're trying to make sure that the bulk of the money from the contributions is saved for the benefits, and staffing up a 800 number is incredibly expensive. And so we've made the choice to use the money more efficiently by using the Contact Us. But as I said, if you want a phone call, just tell us and we'll call you back. I keep telling you to go to our website. I want to make sure you know our website is ctpleave.org. Make it a favorite, bookmark us, check us out frequently. As I said, we are updating it frequently, and that is sort of the home page. That's where your account is for remitting contributions. So all the information is, as well as information about submitting claims starting in December. So, all right, I'm going to stop sharing and start looking at the questions and answers that have been coming in. All right.
Hey, Erin, I've been trying to tackle some of them for you because we have a very active group this morning, which we love.
Thank you. I appreciate that. It was so nice to see the numbers going down as well as going up. First question is, if we have 100% short-term disability coverage, how would the paid leave payments work? Well, it really depends on what your insurance policy says. If your insurance policy says that they are the payer of last resort, then the employee would come to the authority first, and they would only access the short-term disability if they exhausted their entitlements through us. On the other hand, if your short-term disability coverage says that they are the first payers, they are primary, the employees would utilize that benefit first and come to us only if they've exhausted it. A question about the 2 extra weeks under pregnancy. Is this if they have calculations? Do all pregnant women receive the 2 extra weeks? Great question. The language in the statute is not great. It uses 3 words that actually all are synonyms: serious health condition, incapacity, and pregnancy. Because under FMLA, pregnancy in and of itself is a serious health condition. And incapacity includes a serious health condition as well as the treatment for that serious health condition. So a person who is pregnant could use those 2 extra weeks if they have complications, or if they need that time to go to prenatal visits, or if they're on bed rest. They don't have to show that it's complications. The real factor here is that it has to be during the pregnancy. And the pregnancy ends with the childbirth, so you don't get 2 extra weeks after. The idea here is to make sure that there's a little bit of, if someone is having a need to take time off before the baby's born, you kind of want to kind of preserve some of the afterbirth for recovery and bonding. If I have employees in another state who work for us as a Connecticut company, are they entitled to this benefit? Another great question. And that really depends on where they are working for purposes of unemployment. So you should really only be paying into unemployment in one state. If they are working in another state, but they are considered to be working in Connecticut and you're paying into unemployment in Connecticut, then they work in Connecticut and they'd be entitled to the Connecticut paid leave benefits. If they work into another state and you're paying unemployment in that other state, then they would be subject to that state's employment laws. All of the states around us offer some version of paid leave. Rhode Island, New York, New Jersey, Massachusetts all offer paid leave. So if they're in one of those states, you'd be under those programs. We've already talked about supplemental short-term disability, so I'm going to skip that one. Question, we get it every single time, which is if someone is out, say in October of 2021 on FMLA, so before the change in January, are they still eligible for the full 16 weeks of leave, or would their return to work date change for 12 weeks? Well, October, November, December, if they can't complete their 16 weeks of leave before the end of 2021, they're not going to get 16 weeks of leave going into 2022. The Connecticut Department of Labor on their website has issued a guidance about how to deal with this situation. And I don't want to summarize it because it's a little bit complicated. But I would encourage you to go to the connecticut.ct.gov/DOL and look at, on the screen, see family medical leave. And they have a very detailed guidance about how to deal with this with examples. But the short answer is you are entitled to look back in 2022 to see what they took in 2021. So a couple questions about the employment verification form. Is it online? Is it physical? It is a paper form that is posted on our website. The sample is, and we'll be putting up the revised one when it becomes available. It will also be provided to the employee when they apply for benefits. It is not we don't have a database where you can just like go into it and complete it online, but you can complete the form electronically in the sense of opening up the form and typing in your answers and submitting it via email. It's a 1-page, 2-sided form. So it's relatively short, just asks for some basic information, helps us get information that we can't get anywhere else, like information about the employee's work schedule, information about the PTO. Which raises a question. We get a lot of supplement questions. Can the employer supplement with PTO for the amount not covered by CTP leave? So basically topping it off. Yep, absolutely. Question about offsets. We are designing our plan to have state benefits pay first, and we will supplement. How will the state view our supplement? We don't want you to offset our benefit. We want to get your benefit plus. And that's great. That's fine. We're actually, just last night, we signed off on a revised form so that we can make that clear as to who's primary, who's supplemental. And if you say you want to supplement, that's great. We pay the benefit and you supplement, and it's on you to make sure they don't go over 100%. We'll help you with that because we will tell you the amount of time that, the weekly benefit that we anticipate paying the worker. When we do that, so you'll get the employment verification form from the worker, and you have to submit that to AFLAC either by email or by US mail or fax if you like. And then when we approve the benefits, we'll notify the employer that the benefits have been approved, and we'll give you the weekly benefit amount. Will there be a 7-day waiting period, or do employees start getting paid from day one? Great question. Unlike kind of every other state, we are paying from day one. There is no waiting period. So assuming that we can get all of the application and the documents ahead of time, there would be, really no delay to the employees about getting their payments. And then, as I said, we will be paying, the expectation is we issue the payments on the Tuesday, and they'll be paid every week thereafter with that sort of 2 weeks in arrears. So, so a person who's going to be getting income replacement benefits, as I said, for January 2nd through the 18th, they'll get that check. January 2nd through the 10th, they'll get that check on the 18th, but it'll cover the absence starting on January 2nd. There is no waiting period. More supplemental questions. How would you determine if CTPL leave pays first or the short-term disability pays first? Well, you have to tell us what your policy says. And so you'll see in your policy what it says. Question about voluntary short-term disability. If you mean voluntary in the sense of the employee can choose whether or not to purchase that, like you let the people come in and sell them to your employees and maybe even help with payroll deductions, but it comes out of your employee's own paycheck, that is not an employer provided benefit, and it doesn't even compute for us. Okay. Just try, it's Amber and I are answering at the same time, so the numbers are moving up and down on me. Is there a limit on using CTPL? What if you have more than one incident per year? Well, the limit is that it's up to 12 weeks in a 12-month period entitlement, and we're using the rolling back method. So the following year, you gain back a day for every day that you used. So if you had one surgery and you received 4 weeks of income replacement benefits, then you'd have 8 more weeks in the 12 months to use if you had another reason. So maybe you have surgery in January, but then in April you need to go out to care for your mom who's sick. As long as you don't hit that 12-week cap, you're good. How many hours should the 2 weeks of PTO be? Is it the regular weekly hours, including overtime? Great question. Technically, this is something that DOL would answer. But my best estimate, based on what I know about FMLA and the way they handle things, is that you're going to look at their regular week. And so if you've got an employee who earns overtime on a regular basis, their overtime would play into the calculation of what is an average work week. Do we have to provide paperwork for federal FMLA and Connecticut FMLA when an employee needs to take FMLA? Another really great question. If you're subject to both federal and Connecticut FMLA, your paperwork needs to include information about both the federal and Connecticut FMLA, but you don't need your employee to fill out 2 identical pieces of paper, right? So like your notice of eligibility and rights and responsibilities should include both the federal FMLA and Connecticut entitlements, but you don't have to submit sort of duplicate papers. And you certainly wouldn't ask the employee to send you 2 med-certs. A little confusing with Connecticut FMLA and Connecticut paid leave. With New York paid leave, you are not caring for your own serious health condition as federal FMLA covers this. Connecticut leaves look similar. Yeah, our entitlement is different than New York. New York has a separate law, which is a longstanding disability entitlements. for your own serious health condition. And so they adopted a few years ago the Paid Family Leave Act, which only relates to the caregiver and family situations. We didn't have that background that New York has, so our Connecticut Fmla covers both your own serious health condition as well as the family leave entitlements. Will there be an employer website? How and when will the employer have logins to begin using this program? So on the ConnecticutPayLeave.org, we have information for employers, but we do not have, at this point in time, a way for an employer to log in to sort of the claims side. It's really, the login is between the worker and AFLAC. And so, as I said, the only piece of information is going to be the employment verification form, which right now you'll either email or fax or send by US mail. Question, does DOL keep track of each employee's contribution? No. We keep track of contributions on the basis of the employers who contribute, and the employers provide us with basic wage information. And then in order to determine if an employee is eligible, we do utilize DOL data to determine their earnings, but the eligibility and the contributions are not connected. For pregnancy, do you get 12 weeks for birth and then another 12 weeks for bonding? No, you get 12 weeks total unless you need the 2 extra weeks during pregnancy. So there's a possibility of 14 weeks, but you don't get 12 plus 12. Can my company policy say that the employers have to use up their employer-provided vacation and sick time before applying for CTPL? Yes, except that if you have to say that if they need FMLA leave, they are entitled to hold on to at least 2 weeks of PTO. So you can't make them exhaust all of their PTO if they're out on Connecticut FMLA. You have to let them hold on to 2 weeks. They are receiving workers' comp that is also a qualifying event and currently on FMLA. Yes, so the FMLA will run concurrently with the workers' comp. I lost the question, but they won't get any CTPL benefits while they're receiving comp. They don't lose out because they're just not accessing the entitlement. It's not like the entitlement goes away. It's just they can't get CTPL benefits while they're getting comp benefits. It's an either or. Okay, so those were the 2 questions. An employee may apply for CTFML and not apply for benefits under CTPL leave. Yep, absolutely. They may not need the benefits, and that's perfectly fine. But they want the job protection under CTFML. No waiting period. So sorry, just trying to see if there's anything that we haven't addressed. People are asking for an employer dashboard to see who has employed and who has been approved. Instead, we are going to be notifying employers when someone has been approved, but as we move forward, we can see if we can make enhancements. But bearing in mind, this is really the employee's entitlement, and it's the employee's money that pays for this entitlement. So, unlike other states where employers do contribute part or all of the money to support the FMLA, it's employees' money here. So it's different in a relationship. So we are at table 1. We hit most of the questions. Even if I didn't specifically raise your question, I think I tried to hit all of the questions that related to supplemental, as well as waiting period, as well as how people will be notified. And one last question before we close. The employer, are we responsible for letting you know when the employee returns to work? Technically, the employee is responsible for letting us know. It is possible that on occasion, particularly if we're doing some sort of investigation, we might reach out to the employer for information, but we don't anticipate asking the employer to be validating the employee's attendance information unless there's a specific issue. All right. I love the fact that you guys were so engaged. I hope that this was helpful. if you had a question that wasn't answered, please feel free to use our contact us. Amber just put the link in the chat, or you can check out our website. A lot of this information is on our website and in the FAQs. Again, we will be sharing the materials as well as the recording, so you will have that to review and share with others. We offer additional webinars. Starting next week, we'll be having worker-focused webinars, as well as additional webinars for businesses and HR folks, and our partner, the State Small Business Development Corporation, WBDC, is also doing a series of webinars helping really focus more on some of the operational issues, like developing things to think about for developing policies and what to do when your employees are out of work and trying to find coverage. So please check those out as well. Thank you, and I hope that you all have a lovely afternoon and a lovely weekend. Have a good day.